Hi, Phyllis Roman with Giamanco Law Partners here, a law firm in Bolingbrook, Illinois. And while we normally do more informative, educational type videos, I thought I'd do something a little more fun and amusing today and react to one of the most fun legal movies that I have ever seen, My Cousin Vinny, and a particular cross-examination in there. And kind of react as a normal attorney would. I've done many trials. I would consider myself a trial attorney, litigation attorney, and so I am in court and have done this particular action many times, but it's interesting to see how Hollywood or anyone else takes legal questions and makes it more entertaining for the masses. Now, I will say this, My Cousin Vinny is actually one of the more accurate legal representations out there. When you're considering things like Boston Legal or A Few Good Men or things like that, it actually is remarkably accurate, and there's not a ton of things that I would change or that would happen differently in a real courtroom, say here in Illinois, versus what happened on the screen in that movie. So, without further ado, let's kind of see what we see here. This is a scene where he's cross-examining a witness for the prosecution who was an eyewitness to the two kids that are accused of murder.
Is it possible the two...
Oh, right there. Objection. Hypothetical. So immediately, if you hear, is it possible, could it be, what happens if, immediately, a hypothetical question, that's not allowed. Immediately, I would be objecting as soon as I heard those three words out of his mouth without even knowing what happened next. Because you cannot ask hypothetical questions. You have to ask what they have personal knowledge of, what they have seen, what they observed, things like that. You can't ask a hypothetical question of a witness. I will say his position is correct, though. In law school, you learn that if you are cross-examining a witness, you are actually close to the witness so that the jury's attention is on you. If you're doing a direct examination, so a questioning of your own witness or your own client, you actually stand at the back of the jury box, and so that the attention is all on the witness rather than you. Seems like a minor thing, but it's pretty commonly taught in law school.
Two defendants entered the store, picked 22 specific items off of the shelves, had the clerk take money, make change, then leave. Then, two different men drive up in a similar... Don't shake your head, I'm not done yet. Wait till you hear the whole thing. So you...
That's actually very good as well. You want to keep control of the witness, particularly on a cross-examination, because they're not there to help you out. He wasn't rude about it, but he was like, no. Wait until I finish my question. Don't start assuming things right now. So he's kind of bringing that attention back to him. So he's the one, quote unquote, testifying rather than the witness.
You can understand this now. Two different men drive up in a similar looking car, go in, shoot the clerk, rob him, and then leave?
No, they didn't have enough time.
Well, how much time was they in the store?
5 minutes.
5 minutes? Are you sure? Did you look at your watch?
No.
Oh, I'm sorry. You testified earlier that the boys went into the store and you had just begun to make breakfast. You were just ready to eat and you heard a gunshot. That's right, I'm sorry. So obviously it takes you 5 minutes to make breakfast.
That's right.
Right.
So those last two questions were good. In a cross-examination, you're the one testifying. You want to say, you testified earlier that you had eaten breakfast. Yes. It takes you 5 minutes. Yes. But the two questions prior to that were open-ended, obviously you looked at your watch, things like that are generally things discouraged and things you don't want to do in a cross-examination. You want to keep it very tight and with yes and no answers for the witness. Again, you're the one testifying, not them, and you just want them saying yes, yes, no, no. You don't want to leave it open so they can go on some long soliloquy answer.
Right, so you knew that. Do you remember what you had?
Eggs and grits.
Eggs and grits. I like grits too. How do you cook your grits? You like them regular, creamy, or al dente?
You could object here, objection relevance. There are times when you don't want to object just because there's no reason to. But if I was the prosecutor, I may allow him one question and then I'd be like, where are we going with this? Because if you don't know, there's a concern. So I would say objection relevance to the judge would probably allow it. Because it's about the breakfast and he had testified regarding the breakfast. How he likes them is not really relevant, but it's within the scope of the questioning. It would be, for me, as a civil attorney, I don't do criminal, I would be trying to put my witness on edge. Hey, heads up, he's doing something here, objection, think about what you're saying.
Just regular, I guess.
Regular. Instinct grits?
No self-respecting Southerner uses instant grits. I take
Same
pride in my
objection,
grits.
really.
So, Mr. Tipton, how could it take you 5 minutes to cook your grits when it takes the entire grit-eating world 20 minutes?
I don't know. I'm a fast cook, I guess.
I'm sorry.
Okay. So this, again, is actually something we are told not to do in law school, and in general I would never do during a trial. It's called that final question. What you do in a cross-examine is you lead up to all of the questions. You like a regular, you had breakfast, you had grits, you saw them before, you saw them after, when you were ready to eat. You don't ask the question, how was that possible? Now, in this case, that's you can't cook grits faster than that fast in 5 minutes. But in general, that final question is, how is it possible, is the question you don't want to ask. What you do is you line all of that up, and then in your closing arguments, when you can make arguments, that's when you say to the jury, I'm sorry, I cook grits all the time. I'm sure you have as well. It doesn't take 5 minutes. It takes 20. So this ties it in better for what the movie is, but in general, you would not be making this statement, this particular question at the end of your line of questioning. Where he's standing right now is where you would stand if it was a direct examination. You see how far back he is from the witness stand? That's where you want to be if you're questioning your witness, so that the jury is looking at your witness rather than you out of the corner of their eye.
Sorry, I was all the way over here. I couldn't hear you. Did you say you're a fast cook? That's it? Are we to believe that boiling water soaks into a grit faster in your kitchen than on any place on the face of the earth?
I don't know.
Well, perhaps the laws of physics cease to exist on your stove.
Objection, badgering the witness. So the first question is fine, saying that it goes faster into your stove. It's really a question. This is aggressive and not really meant to, it's not really a question, it's a hypothetical. The laws of physics, I'd be objecting right here too. Again, to break that up and bring attention away from what's going on and try to stop what's happening.
Were these magic grits?
Again, objection.
Did you buy them from the same guy who sold Jack his beanstalk beans?
Objection.
There it is.
Objection sustained.
I would have objected
Sure
sooner,
about that
but
5 minutes?
yeah.
No other question.
Are you sure about that 5 minutes?
I don't know.
I think you made your point.
Are you sure about that 5 minutes?
And again, at that point, you don't scream in a witness's face, right? It's very fun and entertaining for a movie. You would never do that in real life. The judge would be like, we're taking a break, counsel admonishing you in front of a jury, which you don't want to have happen. Don't, badger the witness, step back, it just breaks up your whole thing. The other thing that happened is there was an objection, and the judge, by the prosecutor, normally you would have to give your basis, but in this case it's so obvious you don't need a basis. So you just say objection, the judge agrees immediately and starts saying sustained, which means that your objection is granted. And he should be stopping all questioning, and he shouldn't have to answer the question. It should be sustained, the judge should be saying sustained, you don't have to answer that question, move on, counsel.
I may have been mistaken.
Again, TV.
I got no more use for this guy.
Amazing. That's a great movie. I highly recommend it if you haven't seen it. I might do some other clips from it because it's very entertaining. Now, while I stopped a bunch and mentioned some objections, again, you wouldn't object necessarily on everything because you don't need to, right? Sometimes you just let things go. But it's a very good example of how you would line up a cross-examination. You ask these yes or no questions. The witness doesn't know where you're going. Did you have breakfast? Oh yeah, you had breakfast. And what did you eat for breakfast? Normally you would not ask an open-ended question, but that one, you're leading up to it. Oh, you had this, and the witness has no idea where you're going with this. And then you would stop before that. How did this happen? How did yours cook in 5 minutes? But again, it helps with the TV. It's incredibly amusing, and I should stop this recording. And great makes for great TV. My Cousin Vinny is a wonderful show, and I hope this was entertaining, and I hope it actually gets you to watch that movie because I love it. I might go watch the whole thing here after I finish this. If you have any questions or if you have any legal issues that you need help with, hopefully not a false murder charge, like in My Cousin Vinny, I hope that you will give our office a call at Giamanco Law Partners. And as always, good luck out there.